Hi, my name is Kristen Weeder, and for the third case for the video argument, I decided to analyze Wallace versus Jaffree. In this case, I agreed with the majority's opinion that an amended statute mandating a moment of silence for prayer or meditation was unconstitutional. Initially, I wondered how prayer would constitute the establishment of a religion. To me, the act of prayer does not encourage any one particular religion because it's included in all religions in some form. But then I considered that a lot of people don't associate with religion at all, and to those people, the act of prayer and mandatory prayer may be very offensive. The majority lined up with my initial thoughts on the case before even reading it, which was that prayer should be kept out of schools, period. The majority relied on the Lemon test to determine that the statute that mandated school prayer was unconstitutional, and Justice O'Connor in her concurrence used the endorsement test to come to the same conclusion. The Lemon test states that in order for a statute to satisfy the Establishment Clause, a statute must have a secular legislative purpose, the primary effect of the statute must neither enhance nor inhibit religion, and there must be no excessive government entanglement with religion. The majority analyzed whether the statute had a secular legislative purpose first and found that it did not. Senator Donald Holmes was the prime sponsor of this statute, and he stated outright that the purpose of the statute was in an effort to return voluntary prayer to public schools, and the state identified no other purposes for this statute. I believe that even without the senator's statements about the statute, that it would have failed the first prong of the Lemon test because of the religious and traditional culture in the South. It's a very well-known fact that Alabama is within the Bible Belt, and that religion is a huge part of life in the South. So it'd be very easy to presume that a statute encouraging a minute of meditation or prayer would mostly be encouraging the prayer part of that statute. The statute ultimately failed the Lemon test because the court could not identify a secular legislative purpose for the statute, and because it failed the first prong of the Lemon test, the majority did not continue on to the second and third prong of the test. I believe if they were to go on and analyze the statute using the second and third prongs, the court would have next discussed whether the primary effect of the statute enhanced or inhibited religion. It's clear from Senator Holmes' statements that the statute's purpose was to enhance religion by introducing prayer back into public schools. I think that a teacher-run prayer using the words Almighty God could also inhibit religious beliefs, though. Those who practiced a religion that did not believe in an Almighty God, this may have inhibited or interfered with the practice of their own religion. Either way, I think it would have failed the second prong of the Lemon test as well. And then last, the court would have discussed whether the statute resulted in an excessive government entanglement with religion. To me, excessive government entanglement means that it's clear that the government is trying to impose religion on the state. And based on the statements that Senator Holmes made, it's clear that that is the government's purpose, that it is attempting to bring prayer back into schools. So I believe that the Alabama statute would have failed all three prongs of the Lemon test had the court been required to examine all three. Justice O'Connor, in her concurrence, took another approach and came to the same conclusion. She proposed the use of the endorsement test as a means of determining whether a statute violated the Establishment Clause. The endorsement test simply asks whether the statute conveys a message of endorsement of a religion. In this case specifically, it was a parent who filed the action on behalf of his school-aged children. They were in separate classrooms, and the teachers led a prayer to Almighty God, and those children who did not participate in the prayer were exposed. They had to expose their religion and also faced ostracism by the other kids. In class, we discussed kind of the pressure that people feel to fit in, especially in moments of prayer and moments of silence. Adults and children may feel compelled to join in just out of respect or out of, that sense of belonging. We even see examples in class where no one will speak out on controversial issues because they're afraid of being seen in a certain way. So it's easy to see how the act of a minute of prayer would endorse religion by kind of a peer pressure effect. So in conclusion, I agreed with the majority's opinion that the Alabama statute would violate the Establishment Clause under the Lemon test. And I also agreed with Justice O'Connor's concurrence that the statute was unconstitutional because it endorsed religion and therefore also failed the endorsement test. Thank you.